Honorable Eric J. Eisenagel, Judge presiding. All persons having business before the court, draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning. Welcome to the 5th District Court of Appeal. I am Judge Eisenagel. I'm joined on the panel today by Judge Boatwright, who's on my right, and Judge Blocker, who's on my left, who's serving today as an associate judge for us. We have one case on the docket today, 24-2368, Ford Motor Company versus Robert Hetzler and others. Let's see, do we have appellants over on my right and appellee on my left, correct? Okay. For the appellants, if you want to tell me how much time you'd like in rebuttal, I'll try to help you keep an eye on the clock. It is ultimately your responsibility and your decision whether you even take a rebuttal, but if you tell me how much time you want, I'll try to help remind you. All right. And are you running the clock today? Okay, great. All right, thank you. All right, with that then, one more reminder. If you have electronic devices, which you probably do, please go ahead and take this moment to silence them or turn them off so they don't interrupt anyone as they're arguing, okay? All right, on the appellant, Ford Motor Company, whenever you're ready, you may begin.
Good morning, Your Honors, and may it please the Court, Jessica Ellsworth for Ford Motor Company. I'd like to reserve 4 minutes for rebuttal. This appeal presents two important questions that are critical to fair trials in Florida. First, the appeal asks the court whether the first DCA's Cassisi inference should be expanded well beyond the majority rule in Florida and in a way that introduces substantial unfair disadvantage to defendants in a product liability case. Under the plaintiff's view, they can use a Cassisi inference to effectively eliminate the product defect element of virtually any product liability manufacturing defect claim. That should not be the law. The inference was designed to even the playing field so that neither party suffers an unfair disadvantage when a product has been destroyed by a malfunction, making it unavailable for anyone to investigate what happened. The trial court here used the inference to substantially tilt the unfair disadvantage in the plaintiff's favor. It did so by ignoring that the engine of this vehicle had been supercharged after it left Ford's control, ignoring that the plaintiff had no evidence of the, quote, normal operation at the time of the fire, and that the reason several components of the vehicle were unavailable for either side to analyze is because the plaintiff did not preserve them. Expanding the doctrine...
So why are you saying the doctrine's been expanded here? Are you saying because that this should only apply to like self-operating items, passive items? I think that's your argument.
That is a piece of our argument. In order to avoid the exception from...
So it can never apply to an automobile?
I don't know that you have to be as definitive to say it could never apply to an automobile, but the majority rule in Florida has applied it primarily in the passive product
Has it
context.
ever been applied in Florida to automobiles?
No, Your Honor.
Are you sure?
I believe that to be the case. There are some cases...
You can see that it's applied regularly, though, by courts around the country to automobiles.
I think it can.
I mean, there's a large number of cases out there, correct?
Certainly.
I've looked at them. You acknowledge that.
What about Miller versus Allstate? Wasn't that an accelerator sticking?
I don't have Miller versus Allstate at hand. I know there are a couple cases that the appellees cited that are lemon law cases, which is a different standard because there it's a statutory rule as opposed to this common law inference. And there are a couple cases that predate Cassisi entirely that involve automobiles but don't allow the same sort of inference that Cassisi brought on. The passive nature of the product, I think, is one factor that would counsel in favor of using it, which is absent here. And that is sort of our point. There are all sorts of considerations that courts have developed to make sure that this remains sort of a fair inference that a defect at time B is an indicator that there was a defect at time A when it left the manufacturer's control. And so for passive products, that's easier to make that leap because you're not using it in a particular way. There's less opportunity for sort of user-introduced error. But it's just one consideration. I think the primary consideration that I would point to here, there are two of them that I think are most important, and that is the modification that happened to this vehicle after it left Ford's control.
So where do you draw the line, though, right? What if you add a spoiler to the back of the Mustang, right? We have a Mustang that, first of all, let me ask you this. Let's just make sure that we're on the same page. Ford presented a number of defenses below. Some of them involved a defense that, hey, it was a cigarette, the engine didn't even blow up. Can we agree that the jury rejected all of those defenses and concluded that the engine did blow up?
Yes, Your Honor.
Okay. So whether or not the car was in the parking lot idling or whether it was driving when it blew up, that we can talk about that. But the jury concluded that this wasn't a cigarette, it wasn't some other defense, the engine blew up.
I think, to be very specific, I think the way the Cassisi instruction was written here was that if the jury was entitled to infer if there was an engine fire, a fire in the engine compartment. And that's really important because that reached well beyond the plaintiff's theory, which was that there was a brake fluid leak in the engine compartment. That becomes important because the Roush modifications here, unlike your spoiler...
I'm just saying we can eliminate the cigarette defense and stuff like that, right? The jury rejected that, correct?
That is correct.
Okay. So if the car blows up, right, barring some strange use, right, if it's just driving or if it's just idling, why is an inference that there was, why should we say, oh, there's no inference because we added a spoiler to the back if the engine blew up, right? Or we added some decals to the side, right? At what point do we draw the line, right? Because the testimony here was clear. Roush didn't touch the braking system, right?
I don't think that it was that clear. When Roush installed the supercharger, and we have the sites in our opening brief, it involved all sorts of work in the engine compartment to the engine, fuel, and electrical systems that included installing, removing, and rerouting in and around the brake system.
The jury heard that, though. I mean, those are facts that went out in front of the jury, and then they made the decision that they made. So.
They did, Your Honor, and I have two responses to that. One is that our argument is that a Cassisi inference should not have been available to the jury in these circumstances. And so before we get to...
Were those brake parts, they were destroyed, correct? I mean, the parts, as I read part of the trial transcript, I think there was discussions among the experts that the specific parts were destroyed in the fire or got lost, correct? So there was no evidence for either side to actually analyze that, correct?
So, Your Honor, that's actually not correct. And we walk through this as one of the factors that we think counsels in favor of not applying Cassisi here. For example, their expert, Coons, specifically told the jury that the ABS module, the anti-braking system module, and its connections survived the fire. They could see it in photographs, and they were a greater possible source of the fire than some of the parts that had been lost. What happened was Ford lost the ability to rebut the plaintiff's theory on these brake parts, and even as to the Roush modifications, because of the loss of this evidence through no fault of Ford's. I think it was perhaps inadvertent by the plaintiffs, but this evidence existed after the fire, and Ford was not able to access it.
As part of Roush, as part of what they do when they modify Mustangs, they do this regularly, correct?
They do, Your Honor.
Is it their practice to modify the braking system?
I think it's in and around the braking system.
In
so
and
you have to move certain elements under the, essentially under the hood of the car.
That's not modifying the braking system, is it?
I agree that it's not modifying the braking system.
So there was at least enough evidence for the jury to conclude that Roush did not modify the braking system, correct?
There was. The problem becomes, I think, that there was also, the judge below denied a directed verdict as to Roush because there also was enough evidence that the jury could have found that the engine, that even if there was an engine fire, it resulted from something that Roush had done. And that becomes important because when we're talking about fairness to litigants.
Why shouldn't the jury decide if there's been a modification or a meaningful modification? We can agree that a spoiler on the back of adding a spoiler on the back of the Mustang should not block the inference, right?
I agree, Your Honor. I think the reason here is that if the Cassisi instruction that was given had been focused on a brake fluid leak in the engine.
But doesn't that defeat the point of an inference? Isn't the point of an inference that, hey, we're not sure what happened, but this shouldn't happen?
So, Your Honor, I think when you have a specific theory that there was a brake fluid leak, the inference gets you. You don't have to identify where that brake fluid leak happened, exactly which connection wasn't tight enough, which tube.
Why would you have to do that anyway?
Well, it is always the plaintiff's.
You have to identify the exact connection?
You have to show that there was a brake fluid leak. You have to have some.
Isn't
But
the
you don't-
point, oh, sorry.
No, go ahead.
Isn't the point of the Cassisi inference that you don't have to show a specific defect, you just have to show normal operation and a malfunction? And you don't actually even have to show that the evidence isn't available any longer. The Cassisi court said that it's most vividly portrayed where the evidence is too badly damaged, but it can be a jury question of whether it's too old, so frequently repaired, or subject to rugged use. Those are questions of fact for the jury.
So, Your Honor, the Cassisi did say that. Cassisi was decided in 1981, and one of the things we do in our brief is look at how courts have applied that inference and put essentially guardrails around its application to prevent it from undermining the kind of eliminating unfairness principles that it started from. And one of the things that courts have looked to is exactly what Your Honor is talking about. Was there a destruction of this evidence as a result of the fire? Is there some sort of superior access that Ford had to the vehicle in the condition that it existed at the time of the fire? And because of the modification, it didn't. If I could just give you maybe an example using the dryer from Cassisi that I think might help make this clearer. Imagine that in Cassisi, the plaintiff had a specific theory that there was a defect in the dryer's lint collector, and it had collected lint and it had caught fire. There was also evidence that the owner had modified the thermostat of that dryer to supercharge it. Any Cassisi inference, and there's no evidence in my hypothetical of what actually happened to cause the fire. The Cassisi inference that the jury's allowed to draw would be about the fact that there was a problem with the lint collector. It couldn't be that the jury can say, well, there might have been something from the thermostat being supercharged that caused the fire, but my instructions say anything that's a fire related to the dryer, I can draw this inference.
So is your issue with the jury instruction or that it was given at all?
We have both, we raise both as I think as problems.
So with the jury instruction, the instruction talked about the fire originating in the engine compartment. I believe it's the next paragraph down discusses the brake fluid and the brake fluid line. Does that next paragraph not cure the defect that you're discussing?
I think when you read those two together, Your Honor, it actually shows that there was a significant problem with the engine fire compartment because the instructions identified the defect that the plaintiffs had to prove as being about a brake fluid leak igniting. And then they were told, but you can infer if there was an engine fire that Ford is responsible. There's a real disconnect between those two statements that were given to the jury. And so what this instruction did was that it opened the number of scenarios that would allow the jury to find Ford liable.
But counsel, so help me out. If the plaintiff proves that it was a brake leak and the brake fluid ignited, causing the Mustang to blow up, why does one need the inference at all?
Your Honor, the problem for the plaintiff here was they had zero evidence of a brake fluid leak.
No. I'm asking, why do they need to be connected? If they can prove that it's a brake fluid leak, right?
Right.
Why do they need the inference?
They would still need the inference because they have to prove there's a brake fluid leak. Proving there's a brake fluid leak requires some sort of evidence that there was a brake fluid leak. They didn't have that, and they were clear about this from the very beginning.
Why should their inference have to be tied to their theory? So they offered the jury a theory for how this could theoretically happen. Why did they have to do that at all? Why couldn't they just rely on the inference? I don't understand why the inference has to be tied to a specific cause, right? It doesn't seem to add up.
So, Your Honor, here, in a sense, I think it comes down to these Roush modifications that happened in the engine.
By the way, I think that's your best argument.
Well, because
I'm not sure the initial brief gets you there, though.
So, Your Honor, I want to make sure to address any concerns you have about that. But the reason that the plaintiffs here had to pick a brake fluid leak is because if they just said there was an engine problem, there is no way to tie an engine problem to Ford as opposed to Roush. So they had to pick something that would enable them to say this was defective when it left Ford's control. So they had to pick something that they thought the Roush modification
Well, I
had.
mean, perhaps they had to establish that it wasn't the supercharger.
And they had no way to do that. They offered no evidence of that other than Cassisi. They said that they were very upfront with the court at the summary judgment stage. They were very upfront at the directed verdict stage that this was a Cassisi case. They needed that inference. That was their path to getting a potential jury verdict in their favor. I do want to address any questions Your Honor has. I'm also happy to talk about Binger very briefly, and I want to save some time for rebuttal. So if I can briefly talk about the change that fundamentally altered the trajectory of this trial and was a Binger violation.
Didn't trial counsel for Ford actually ask the question that you're most concerned about?
Yes, Your Honor.
Well, then how do you prevail on appeal?
For exactly this reason.
Ford's trial counsel asked the question.
Ford's trial counsel asked the question after the plaintiff's counsel asked Mr. Dyer about the new information.
Of course he would ask that, right? I mean, I read the transcript, by the way. I read this part. We'll give each side some additional time. I read the transcript here, and all plaintiff's counsel did was say, hey, we had some new information come out yesterday. That was a surprise. Does your opinion change? Was it Dyer? Mm-hmm. Dyer says, no, my opinion doesn't change. Then counsel for Ford gets up and says, well, is that what happened? Do you think that's what happened? And he answered the question. I don't understand how you get a reversal on that.
So, Your Honor, I think when Mr. Dyer acknowledged and direct that he was considering this new information.
No, he said it didn't change his opinion.
Right.
That's different than, yeah, my opinion is he was driving when the car blew up.
Well, we know that his opinion was that that Mr. Hetzler was not driving when the car blew up. We have a number of sites in our reply brief that walk through Mr. Dyer agreeing.
His opinion was where the source of the fire originated, correct?
His opinion had to.
So how did that change whether he had been sitting there idling or whether he drove in? How did that change his opinion? The opinion to the source, as Judge Eisnagel said, it didn't change, correct? As to the source of the fire, which was what he was called to testify to?
So he was called to testify to the cause and origin of the fire. And the cause of the fire in his pretrial deposition was consistent with what Mr. Hetzler said all the way back to his complaint. That
brake fluid ignited.
Leaking brake fluid in a parked vehicle ignited when it hit the hot exhaust.
I don't think I didn't read his opinion as being critical on, critically tied to whether the vehicle was in idle or not. He just said, hey, look, the engine blew up because brake fluid ignited on a hot engine. So then when the firefighter unexpectedly the day before says, oh yeah, the plaintiff said that he was driving when it blew up, right? Now that injects a sort of a surprise fact that I think everybody was surprised about. because somehow the firefighter wasn't deposed, right? And now what does plaintiff's counsel do? Simply says, does that change your opinion? I don't see how he's literally saying that didn't change my opinion. And then counsel for Ford gets up and asks the additional very open-ended questions that bring out what you're worried about.
I think what counsel for, I think if
How did counsel for Ford not open the door?
Your Honor, I think what opened the door and what the door that Ford's counsel was trying to close was this idea that the plaintiffs would be able to later say, the reason you should believe Mr. Dyer's theory, which is scientifically invalid,
Well, that's a different issue. Let's stay on this one.
Okay, so Ford wanted to make sure that the door had been opened for the plaintiffs to say, the reason you should believe Mr. Dyer's theory is because this was actually a driving car. So everything Ford is going to tell you about the fact that...
Yeah, but that's based on the firefighter's testimony the day before. And then plaintiff just says, hey, does that change your opinion? We heard this firefighter say, what he said. Does that change your opinion? Dyer says no. And then Ford's counsel gets up and says, well, what do you think happened? And he answers the question. I will give you an additional 4 minutes in rebuttal, and you have 30 seconds here, so.
Okay. Your Honor, I think that the fairness of this trial was undermined by two things, one of which is the Cassisi inference that is far broader than any inference that any court in Florida has ever allowed, the circumstances of this case. And secondly, as the trial court noted, this trial was fundamentally altered when Mr. Dyer evolved his theory into being igniting brake fluid in a moving vehicle. And for each of those reasons, the court should reverse.
Thank you, counsel. You have 3 minutes and 55 seconds in rebuttal. Counsel, of course, will give you an additional 4 minutes if you need it. And you are recognized whenever you're ready.
Thank you and good morning. May it please the court, I'm John Mills on behalf of Robert Hetzler and his children. Next Monday will mark the 8th anniversary of this car fire. The plaintiffs brought this lawsuit against Ford 5 years ago. That started a long judicial process that we're now at the end of.
Counsel, there were modifications made here, right? This wasn't just a Mustang right off of the lot, right?
Absolutely.
And it wasn't a spoiler.
Correct.
When the problem's in the engine, it's not a spoiler. I mean, there was substantial work done, in and around the engine. Why is the inference available?
Because none of the work, there was no testimony, no evidence that anything Roush did to the supercharger, working around things, or whatever could cause the car to catch on fire or explode. Nothing. There's no evidence of that. They didn't argue anything to the jury of, oh, well, it could have been the supercharger. If appellate counsel had been there, maybe she would have made that argument. But the trial lawyer made the decision of what arguments were supported by the evidence, and they didn't make that argument.
What evidence was there? Wasn't there some? I know there was some evidence in the record, but was it presented at trial of Roush employees saying, no, we don't touch the braking system or something? What evidence was there?
There was ample evidence. There was evidence both from our expert, Mr. Kuntz, but also from each of Ford's experts and its corporate representative, that they'd all reviewed this, and Ford knows Roush is going to modify these. They have all these specifications, and they know what Roush did. And Roush didn't do anything to touch the hydraulic brake system, nothing whatsoever. There were no modifications to that. Nothing they did could cause brake fluid to leak.
They modified the engine, but they did modify the engine, correct?
They did modify the engine.
So what about the instruction as to appellant's question that the instruction was maybe too broad because the instruction dealt with a fire in the engine compartment? So why shouldn't it have been more specific to a brake fluid leak?
It was, as you recognized just a moment ago, Your Honor, it was.
So you think that second paragraph would cure?
It's the very next sentence. It's the jury was given these instructions. The very next sentence after that says what our claim is and what we have. The issue for your determination is whether brake fluid leaked and ignited.
So if that paragraph had not been there, there might be an issue?
No, because if you look a few paragraphs above that, the very first instruction that says what the party's claims are says that's what plaintiff's claim is. Plaintiff's claim is that brake fluid leaked and ignited. So the jury was told that at the beginning of the instruction and at the end of the instruction. It's sandwiched it. And they create this false dichotomy between an engine fire generally and a fire started by brake fluid. There's no evidence in this case of an engine fire starting by any kind of fire starting in the engine compartment other than by brake fluid. So we use shorthand. The instruction they're talking about doesn't repeat the same phrase that's right above it and right below it, because that's the only thing we're talking about. Ford never suggested that an engine fire could be caused by Roush or anybody else. They never did. There was no evidence. The only thing, and maybe I overlooked this, and I don't want to overstate things, in closing argument, Mr. McDonald, there's one paragraph he briefly says to the jury, now, Mr. Kuntz couldn't rule out that Roush did something that could have caused this fire. The jury was free to reject that, because if you look at Kuntz's testimony, he never conceded that. He never said he couldn't rule it out. He did rule it out. He said this was the area of the fire from Mr. Dyer is right at the master brake cylinder, which was destroyed. It was destroyed. They say it wasn't destroyed. I don't understand that. It was destroyed. The ABS module was melted and removed by salvage, but we didn't say that's where the defect was. We said it was in the master brake cylinder, which completely melted away. Who cares about the ABS? If it hadn't been salvaged, we could look at it and say, yeah, there's no defect there. It was where we said it was. Or we could look at it and say, oh, it was there. We win. It doesn't matter.
Were any of those parts available before it got salvaged?
No, those parts were not available because they melted in the fire. There are pictures at the scene that the jury saw that showed it's gone. Their expert or their argument, I think Mr. McDonald said, well, maybe it just fell off and we don't know and they lost it. That's silly. There was a fire inspection. The fire department was there. All of that was done before any parties did.
So what do you say to their argument that Cassisi is applied too broadly here, that it should only be applied to self-operating, passive-type electronic equipment?
I would say that that's absurd, that this is broadening Cassisi.
Has it been applied to automobiles?
Day in and day out, and yes, in Miller, it was to a car that was driving. And it's been applied. Cassisi cited airplanes being flown by pilots.
The Miller case, as Judge Blocker said, was a sticking accelerator. Is that correct?
Yeah. And we've cited other cases. Some of them are lemon law cases, but so what? It's the same concept. This court has said it's applied it to 3 Ford vehicles so far.
How do you distinguish from the Ainsworth case where the 4th DCA said that they weren't entitled to a Cassisi inference because there wasn't any testimony of how the fall occurred? There was a witness who saw the person on the floor. Is that analogous to this case, or is there any distinction?
There's lots of distinctions. First off, in that case, nothing was destroyed. It was all available. Here, we have the destruction. But more importantly, it was a unique procedural posture. It wasn't a Cassisi case. It was a Daubert case. It was an exclusion of the 3 experts of the plaintiff. And the trial court said, no, there's not a sufficient basis for this to come in. And so the judge, early in the trial, excluded the 3 witnesses. At that point, the plaintiff said, well, we can't win without that, Your Honor. Plaintiff hadn't even put on his testimony. Said, well, you just entered a DV against us so we can challenge the admissibility of these experts on appeal. And so the trial court did what he asked, and it went up, and the appellate court said you didn't even ask for Cassisi at that time, and you hadn't even put on the testimony, so how can we consider it? So I think that that's very distinguishable here, and more importantly, they talk about that this is broader than Cassisi. That's absurd. Let's go over. Cassisi identified 5 factors, and this court, in the Torres decision, said these are the 5 factors that the defense can use to rebut the inference. So first off, these aren't things we have to prove. We just have to prove malfunction during normal operation. And then these are things the defendant could use to rebut it. We still bear the burden of proof. The jury was told you can infer, but you don't have to.
That's if you haven't modified it.
Right, if it hasn't been
I
modified.
mean, we have a modification here, so we're kind of wrestling with
There's no
what's a
need-
relevant how do we know what's a relevant modification? I mean, I think we all can all agree the spoiler on the back wouldn't be relevant, right? So
It would be relevant if they had testimony from anybody that said, this is what Roush did, and this is how what Roush did could have caused a fire if something Roush did went wrong.
Is it fair to put the burden on them if they're not the ones doing the modification and they weren't in possession of the vehicle?
Well, first off, they did know what the modifications were. This is a deal between Roush and Ford. It goes straight from Ford to Roush. So they knew what the modifications were going to be. But no, the burden remains, this is what the court said in Cassisi. The burden remains on the plaintiff in the legal sense, but in the very limited sense that if the defense fails to counter the inference, he runs the risk the jury may find against him. That's what happened here. Nothing, no argument by counsel, and certainly no evidence by an expert or otherwise that there's anything that Roush could have done that could have contributed to this fire. Wild speculation. A supercharger. Well, they knew it was a supercharger. Supercharger didn't have anything to do with the brakes. It didn't. There's no evidence of that. There was no argument to the jury. Mr. McDonald said it doesn't matter whether he was driving or he was parked, we win because the fire didn't start in the engine compartment. It started in the passenger compartment. That was their defense. They went all in. And we built a jury instruction that protected them. It required the jury, it told the jury, it focused the jury that this is a conditional inference, as Judge Wallace said. It's conditioned on the plaintiff proving beyond, by a preponderance of the evidence, that the fire started in the engine compartment. So if we didn't prove that, we lost. It was over. If it was a pass, and that's all this was about. The trial was about one fact, and unfortunately, this appeal, striking from the briefs, it's striking. We don't disagree on any legal principles of note here. We all agree. The case law we're talking about, two eponymous cases that have been cited hundreds of times. They've been applied. They're beyond dispute. What we disagree about is what's in this record. That's
So
your
how-
job in this case.
What do you have to prove as far as normal operation, when it comes to a vehicle? You didn't offer a lot of evidence on, how the vehicle was being operated, although you did offer some. So at what point, and sort of in your defense, I'll just say I'm not entirely sure the initial brief is sufficient on this point, but what would be not normal operation for a Roush Mustang?
Well, first off,
is there any speed that one could go in a Roush Mustang that would render it sort of the use not normal?
I don't know. Maybe. But there has to be something to tie. There has to be an evidentiary
If
basis.
you took it out to the Daytona racetrack, right, I don't even know if they do that, but if they let people bring their cars and drive around the track as fast as they can do it, and you take the Mustang out there and I don't know how fast these things can go. Let's say it can hit 180,
Right.
and this happens. Is that normal operation for a Roush Mustang?
Designed to go 180 miles an hour, then yes, that's normal operation, but it doesn't matter because there's no evidence here that speeding, that anything, any driver could do to this car.
But did you have to say, hey, but we weren't speeding, and I understand you're.
No. We would if there was some evidence that speeding could cause the engine to blow up, but there's no such
Well, I think-
evidence.
No, in fairness, I think you'd have to, I think if speeding would be not normal operation, then you would have to offer some evidence that you weren't speeding, right? So I guess that's what I'm asking.
I think you have to tie it to, I think the normal operation has to be tied to the event. And in any event, there's no evidence whatsoever that he was speeding. The only evidence is he was doing one of two things. If you believe what he told the fire department at the scene right after it happened, he was driving down a street when his car caught on fire.
He was driving and it blew up.
It caught fire.
Yeah, well,
And he pulled into the bank,
the
and it
firefighter-
blew up as he opened the door to get out.
Okay, well, I told the firefighter it blew up, but.
It did blow
That's
up.
what he said.
Absolutely, yes. The car blew up. That's what injured him. He said that he pulled in where it blew up because it was on fire.
So is
If
the
it blew
evidence-
up, he would have, on the street, it would still be on
So
the
it's
street.
just saying that he was driving when it blew up or when it caught fire. Would that be, and, obviously, it's your position, that's enough to establish that it was normal operation?
Yes, driving a Ford Mustang is normal operation, as is parking it, is if you
He
believe
wasn't
what is...
attempting to fly it anywhere, like he didn't install wings and attempt to take off or
Correct,
something like
correct.
that. He wasn't doing Dukes of Hazzard sort of jumps or...
There's certainly no evidence that he is the kind of person that would do that he did it that night, that he ever did it, that he was speeding, that there were witnesses who saw him do something.
And that'd be a good example of not normal operation, right? Trying to jump the Mustang off of a ramp or something like that, right?
Yeah, that could be. That
For
could
sure.
be.
Come on.
But this vehicle was, their own witnesses said, it examined it, there was no collision.
And if the jury believed that he was idling in the parking lot, I mean, clearly that's normal operation.
Absolutely,
Right.
absolutely. And our expert didn't care. He didn't care. There's no Binger violation. Again, they're just being dishonest about the
Question,
record.
counsel, was that counsel for the plaintiff or counsel for Ford that asked the question? That's the problem, that Ford is arguing is the problem.
Well, they didn't object to anything until we objected on their cross. They asked these silly questions. They still have not told you what Mr. Dyer, what was he supposed to say? Was he supposed to lie? What was he supposed to say? What was wrong about his answers?
Who asked Dyer what Dyer thought happened?
It's exactly as you remembered. They did. We offered 5 opinions that were disclosed pre-trial, and we offered them exactly the same at trial. Exactly the same. Not one of those opinions had anything to do with what he was doing before the fire
Is there any
started.
situation in which a counsel can ask a question, inviting an answer to it, and then assign that as error on appeal?
Not that I'm aware of, and it's funny, they cite, there is an example where a question on cross can lead to a basis to challenge something on direct. They cite the Barrett case, which was a criminal case, where the state's fingerprint expert, said, well, the fingerprints match on direct. And on cross, defense counsel said, well, when did you try to test those? After my deposition, I did. So that's what established the Binger violation, was that he did something they didn't know until they asked him. Well, Ford asked the same kind of question, and they got confirmation that Dyer did not know and didn't perform any tests on this before trial. Dyer, like the rest of us, learned about Castleman's testimony for the first time during trial.
Anybody depose Castleman during this whole process?
No, it's in the record. Not only was he not deposed, he wasn't even interviewed. You
They had
can't.
an opportunity to depose him if
Yeah.
they wanted to? He was on your witness list?
He was. He was. And he was the author of the report that said the car just blew up. And so we didn't want to just rely on a report. We wanted to have him say it. And he said it, and nobody thought that 7 years, 6 years, whatever, after the fire, he would have a memory. But oh my God, he sure did. He would never forget this. He spoke to a man that looked like a scarecrow and had skin falling off his body.
So, counsel, if going back to one of the arguments made by Ford here, if you were able to prove that it was a brake fluid leak, or the brake fluid ignited that sort of caused the engine to blow up, then why do you need the inference at all?
We didn't in the end. I think we kept thinking they were going to say Roush did something, have some evidence of something Roush did. And at the end, I don't think we needed it. I think you're exactly right. It's harmless, other than it helped them because it cabined it. It made clear in an instruction that you have to find that the plaintiff has proven it happened in the engine compartment. Once you do that, then our expert testimony is direct and undisputed. Unlike Cassisi. In Cassisi, the expert said, I can't rule out that this house had bad circuit breakers or didn't even have circuit breakers at all. That's a non-defect cause that he could not rule out. Our experts did rule out all the non-defect explanations. They did. They said they did. Dyer and Kuntz both said they did. We provide the transcript sites for that. Ford never disputed that. They never did come forward and say anything other than a defect that could have caused an engine to blow up, for the fire to start in the engine. They never did. Read that closing argument again.
What evidence was there that, and it doesn't need to be undisputed, but what evidence was there that Roush, that whatever Roush did not, could not, or did not cause the
The
problem.
direct, explicit opinion of every expert in this case to opine on it. Our experts certainly said that, and that's all that matters. Our experts said it, and the jury was entitled to believe that, even if their experts said, oh, no, it could have been this, that could have been that. But their experts didn't say that. Their experts agreed. We got them across, all of them, to agree there's not one thing that Roush did that contributed to this fire.
A supercharger couldn't have done this, essentially.
Exactly, exactly. So that is undisputed. It doesn't have to be, they could have said, oh, it could have been the supercharger. They could have done what Miss Ellsworth did to you. They could have said that, and they would have looked silly doing it because there was no evidentiary basis
Plus
for that.
testimony that they may have been working in that area, but that's something the jury gets,
Well,
that's a jury question, correct?
Exactly, Judge Boatwright, but it didn't end there. There was testimony that it worked there, and there was additional testimony that Ford designs its automobiles to be worked on. It knows that over the course of a vehicle's life, people are going to do maintenance. They're going to work around the brakes. Heck, they're going to work on the brakes. But certainly, they know Roush is going to be working in this area. They knew that, so they designed it to withstand people working in the area. You drop a wrench on it, it shouldn't cause a latent defect that happens 1,000 miles later to blow up. There's no evidence to support that. That's rank speculation by an appellate lawyer.
What about this rerouting, what the initial brief says, removing, adjusting, installing, and rerouting components through and around the braking system? I understand around the braking system, but the specifically through.
Well, that's what I was trying to get at. So they did not reroute any braking components, any fluid, brake fluid components. They worked around the area. And the vehicle was designed to withstand somebody working around the area. They drop a wrench, they knock something accidentally, that's not supposed to cause an engine fire 1,000 miles later. It's not. Okay?
Why did they say in the initial brief, quote, through the braking system?
I don't know why they said it. I don't know why they said half the things.
Do you feel like that's an inaccurate statement then? Saying through the braking system? That makes it sound like they took the braking system apart in some way and put something in and
I do think that's
reassembled.
inaccurate, and you have to remember, it's not just what the evidence is, it's what the evidence is in the light most favorable to the plaintiff. This is a directed verdict appeal. Every inference is in our favor that the jury could do. And certainly with that, there's nothing for the jury. They were perfectly reasonable to say that nothing Roush did. There was no argument. You know, it's telling when the trial lawyer is in front of the jury and doesn't even make an argument, and an appellate lawyer comes in, oh, well, it could have made a difference. Well, if it could have made a difference, their trial lawyer should have made an argument about it. He didn't, with good reason, because there's no evidentiary support for what she's saying, for what they say in their brief. I wrote down 8 things where we disagree. I'm out of time. I think that the court understands them all.
You have 3 minutes.
Okay. Oh, okay.
You don't have to use all 3, but you got 3.
Yeah. Was there evidence anything Roush did could have caused the fire? We've been over that. Were the allegedly defective components consumed by fire? We went over that. They say they were not. The evidence shows they were. Were the jury instructions tied to our theory about braking fluid? They say no. The record says yes. On Binger, did Dyer tell Ford that he did not rely on the accuracy of Robert's hypnotically induced testimony? He did. They say he didn't. They cite his deposition, his first deposition on direct. And he had a quote that they quote that makes it sound like he was accepting Hetzler's testimony. They took a second deposition, the whole point of which was to understand why he disagreed with their expert Smith. And they spent an entire deposition that they ignore, and we cite and give you all the transcript cites, where Dyer told them, I'm not relying on his hypnotically induced testimony. That's not reliable. Mr. Smith, their expert, did what no reasonable expert should do. He accepted that at face value and built his timeline around it. They say we tricked them, but the record shows we told them. I told them at the summary judgment hearing, you're planting your flag on that. My trial counsel used to plant the flag on it. I said, we're not assuming that this is true. We're going to put on evidence. We're going to argue that he just pulled in and it caught fire and it blew up right away. So they knew that was our position pre-trial. Judge Wallace warned them. He told them that was going to happen. He said, if you think there's a Binger issue with that, jump up and tell me right away. They didn't. There was no Binger issue. The only jumping up was us when they tried to tell the jury, suggest there was something wrong with the trial lawyers telling Mr. Dyer what Castleman said. And there wasn't, because the reason they did that is Ford had experts excluded for the very purpose of allowing them to hear this testimony. Did we offer any opinion by Dyer about what Robert was doing? The court's already recognized we did not do that. What was Dyer supposed to say in response? They've yet to give you an answer. There's nothing in this record that he could have said other than what he said. They want him to lie.
Well,
He can't
they
lie.
asked the question, he answered it, right?
That's right. You ask a question, you live with the answer. And so with that, this is an easy affirmance. There's no legal issues here for you to resolve respectfully. The legal issues are clear. It's which of us is telling you the truth about this record in the light most favorable to the appellee, as the standard requires. An experienced trial judge gave them every opportunity to make the record. Just like you, he extended the time. They've got all the due process in the world. Judge Wallace explained his reasoning in great detail on the record for you to check his work. Look at this record. All it is read the record. See which one of us is correct. Is our brief correct, or is theirs? Ours is correct, which makes your job, hopefully, very easy.
Thank you,
We ask
counsel.
that you affirm.
All right. Counsel for the appellant, you have 3 minutes and 55 seconds. I'm interested to hear about the routing components through the braking system, if you'd like to address that.
Certainly. So there is a string cite after that sentence in the brief, and I think that is the evidence that we would point the court to that talks about how components were moved as this Roush modification happened. No, I heard my friend on the other side say Ford knows how a Roush modification is done, and that is true. But the question in this case is how was it done, and was there some problem that happened with this vehicle? Was there an error in how that Roush modification occurred here, not what parts were touched? And so I think my friend's argument misses the forest for the trees by pointing out that Ford knows in theory what a specification looks like for a
I mean, in
Roush
fairness, though, I
modification.
mean, I think this is your strongest argument. I already said that, but I mean, if we take that to its logical conclusion, why wouldn't any repair, anytime a car or a dryer or anything needs any kind of repair, why doesn't that eliminate the inference then?
Your Honor, I think if there has been a repair or a modification of the very part.
Repair and modification are different, but a repair so if something has to be repaired and then it fails, the inference is unavailable.
These are, I think, at the end of the day, judgment calls the court has to make about what makes a trial fair and what makes use of the inference fair. And if the repair is something minor that is unrelated to the part of the product that is alleged to have had a defect, you might have there could be more minor repairs, there could be more major repairs. It would depend on how closely tied it is to whether you can reasonably infer a defect at time A from a problem at time B. I think it is, in the end, sort of a judgment call. I want to touch very briefly on the instruction, because I think this is a significant part of the error. Their theory was that the defect was X. And then what they were told, what the jury was told, was that if you find a fire in Y, you can find Ford liable. We asked for the narrower instruction. So for my friend on the other side to say it doesn't matter what was used, it wasn't a problem, we asked, and they fought tooth and nail against that narrower wording that would be linked to the defect.
I don't think he said it didn't matter. I think he said the previous instruction talked about brake fluid. Then you have the more general Cassisi inference, and then again, they talk about the brake fluid leak. So I think that's what he said. So can you address that is, in context, seems to sustain a Cassisi inference. So I mean, what is your position on that?
Your Honor, it is the plaintiff's burden to show that there is no chance that this error infected the jury's verdict. The trial court here denied a directed verdict on Roush because the trial court found, contrary to what my friend has told you, that the trial court found that a directed verdict against Roush would be improper because there was sufficient evidence for the jury to conclude that Roush had done something that caused this fire.
What is
in
the
engine.
standard of review on giving this instruction? Is it de novo or is it abuse of discretion? Isn't typically giving a jury instruction abuse of discretion? I know you mentioned it being de novo.
I think there are both forms apply in this case because our argument is there should have been no Cassisi instruction available. That is de novo, but the precise wording that was used in the
So
instruction.
the wording is abuse of discretion.
Is abuse of discretion, yes. And then the last point I want to make, and this picks up on a question you asked Judge Blocker and Judge Eisnagel, you picked up on. In Ainsworth, the fourth DCA held that there was no Cassisi inference available where a plaintiff lacked evidence of how the product was being operated at the time. And went out of its way to say you needed firsthand evidence of that. That is missing here. At summary judgment, to avoid summary judgment, the plaintiffs pointed wholeheartedly to the fact that Mr. Hetzler was sleeping in a parked car at the time. Of course, they tell you 6 times in their appeal brief that's not what he was doing. So there is no evidence, no firsthand testimony from anyone who saw how this vehicle was being operated, what was happening, and under Ainsworth, that alone would be a reason that a Cassisi
So
inference.
substantial competent evidence isn't enough, it has to be like an eyewitness?
So Ainsworth says it has to come from the plaintiff himself or an eyewitness.
Is that
is
an expansion or an addition of requirements that weren't present in Cassisi?
I think it is a focus on when is a Cassisi inference a fair thing to even the playing field as opposed to tilt the playing field. And Judge Eisnagel, I would push back on the idea that there was substantial competent evidence here. You had one person 7 years after the fact with a hazy recollection that he, quote, kind of thinks he remembered a statement that didn't appear in the contemporaneous document of what happened that night that he wrote at the time. So for all of those reasons, we would ask that this court reverse the judgment below and send back for a new trial with a correct application of Cassisi and Binger. Thank you, Your Honors.
Counsel. And with that, we are adjourned.